Marital captivity is a human rights violation. Good evening, and thank you, Chaim, for this important conference and for inviting me here and for the very interesting talks. The name of my talk, as you can see, is Marital Captivity is a Human Rights Violation. The magnitude and scope of this human rights violation was underscored to me recently as a result of a conference held in Amsterdam this past November in which I participated. It was entitled Marital Captivity, Divorce, Religion, and Human Rights. Marital captivity is the term used by a Dutch NGO, Femmes for Freedom, when translating the word aginut. It is a term used to describe the phenomenon that is increasingly plaguing the Muslim population in Europe, the inability of women to leave their failed marriages. It is this fortuitous translation which, in my humble opinion, underscores the harm done to women, in particular Jewish and Muslim women, when living under religious laws. And it is this translated term that has enabled me to look anew at the work that I have done, and for all intents and purposes dedicated my life to, helping Jewish wives who want to end their failed marriages. And here lies the thesis of my talk today. Religious rules place all of us Jewish women who marry into a state of marital captivity. All of us, including me, including all of you who married in accordance with Jewish law, including those of us who may never ask to escape our marital captivity, and includes those of us who don't even know that we are being held in captivity in the first instance. Here you see, this is all of us. None of us has the power and freedom to leave our marriages without our spouse's consent. We are all de facto and de jure imprisoned. If you come away with nothing else from this talk, this is what I want you to remember. Religious rules place all Jewish women who marry into marital captivity. And the state of Israel forces all of us to marry this way, placing all of us by state fiat and law into the status of captives. The problem of the Agunot, right, the problem of the aginut, which I represent here with the get of the trial of Vivian Amsalem, the rule that penalizes the adulterous wife, the letter A, right? The regulations that limit the rights of nursing mothers, the problems against the forced divorce, the prohibition against the forced divorce, the horrible stigmatization of innocent children as mamzer, all of these rules, all of them together are crafted to keep all of us Jewish women in a state of marital captivity. All of those rules are variations of the same broad-based phenomenon of the marital captivity of Jewish women. And it is all of these rules, which violate human rights in various ways. They infringe on women's liberties, on their liberty, on their right to privacy, on the rule of law, on their right to equality and a fair trial, and to the security of their person. In this short talk, I will illustrate how these violations take form. Liberty. First, and perhaps for most, liberty. This is the human right that is most basic. It is enshrined in the Universal Declaration of Human Rights. Everyone has the right to life, liberty, and the security of person. And even in the state of Israel's basic law, it is what? The state of Israel denies its female citizens when it adopted Din Torah religious rules as its divorce regime, which you see here, the Rabbinic Court's Jurisdiction Law of 1953. Jewish law, which is the divorce law of the land in the state of Israel, denies all causes of action for divorce to Jewish women. There's absolutely nothing a Jewish woman can prove to enable her to be released from marital captivity. Nothing. Only her husband's will will release her. Until he agrees to release her, she is captive. And that we saw very well in the film. She kept asking for get, he said no, and till he said yes, she remained married to him. This is well illustrated in two recent prominent Israeli cases. In the first, A man is being held in prison for about 15 years for Get Refusal. The state put him in jail for a period that goes beyond the time frame allowed by the law. His wife is still in marital captivity because he has not agreed to divorce, and bound by Jewish law, there is nothing more that the state can do. The second case is the case of Shai Cohen, also a man held in jail for refusing to divorce his wife. Shai jumped out of a bathroom window one day when he was in the rabbinic court for a hearing. The state sent out the troops to capture him. State rabbinic authorities asked for the help of Interpol to find him. State diplomats have asked European states to amend their laws of extradition. But even if Shai Cohen had been captured by the troops or by Interpol, and even if he could be extradited, Shai's wife would remain in marital captivity until he agreed to divorce her. Her liberty is denied, as I remind you, is mine. The only difference between us is that I have not yet asked for release, and I don't think I will, but I've been married for 40 years, so it doesn't look like it. Okay, anyway, Ariel Rosenzweig, who's the dean of Tel Aviv University Law School and a religious man, was one of the first to make the links between Agunot and human rights violations. In a Knesset committee held in 1994, he noted that the basic concept of human dignity and the sanctity of the life of a human being as a free person absolutely cannot be reconciled with recalcitrance to give a get or with aginut. Okay, the next is privacy. So we did liberty, right? Liberty is basic. We're not free. None of us are free. Privacy. Jewish divorce rules and this Jewish state that incorporates, enforces, and imposes those rules also infringes on our privacy. The right to privacy is enshrined in the Universal Declaration of Human Rights. No one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence, as well as in our basic law. Number 7, all persons have the right to privacy and to intimacy. Nonetheless, the sex lives of us Jewish Israeli women are subject to the scrutiny of the men and the state who hold us in marital captivity. If they, the state and our husbands, suspect that we may have had sexual relations with another man, the state will note this in official divorce papers, put us on a blacklist, and only allow us to marry that other man after we prove that we did not have sex with him. To that end, the state has promulgated regulations. It's regulations limiting the ability of divorcing couples to marry in the future. And I have here, by the way, the regulations which I have expanded on, but I'm not going to read them right now. But these are actually temporary regulations. Okay. Okay, to that end, the state has promulgated regulations that mandate that a sex trial be conducted, overseen by a tribunal made up of all men. Now here is a protocol, which I will, because I think I have some time, from such a trial. In this case, the trial was held before the divorce at the insistence of the husband. Thus they, the state and the husband, keep you, or me, in a type of limited marital captivity even after your initial release from your ex-husband. Okay? So here is just, I'll read a little bit. The husband brought a private investigator to testify about the relationship of the wife with a strange man, insisting to the court that he did not see the actual insertion of the quill inside the inkwell, which is a euphemism for the sexual act. The private investigator was questioned, and the copulator cross-examined. Copulator is my translation for the term boel. After investigating the copulator and after the purported evidence was introduced, the court stated, "We declare that there's no evidence before the court of any misdeed." Later, however, the husband introduced pictures of the parties sitting in a car, as well as a printout of the calls that indicated that the woman made phone calls to the man. And the court held, "Regarding the allegations concerning X, I do not make light of them, even though there is no evidence of the actual insertion of the quill inside the inkwell. These are serious allegations." In other words, what happened in this particular case was they held a sex trial to establish whether she actually had sexual intercourse or not with this particular man. But when they couldn't actually prove that she had actual sexual intercourse, meaning the inkwell and the quill, what they did was they held that he still wasn't acting properly, and therefore they put her still on the blacklist as tainted, and it has affected her. So now, next, if they, the state and the husband, want, They can similarly limit you if you happen to be nursing at the time of your divorce. Without the special permission of the state, you won't be able to marry another man. In other words, if you're divorcing and you're nursing a child, you're not allowed to marry another man without the special permission of the state. Jewish divorce laws assume that your milk belongs to the man who had previously held you in marital captivity. And the state wants to make sure that that man's rights to that milk are not compromised. As a condition of the new marriage, the new husband will have to pledge to feed the ex-husband's baby. And so there are regulations. And this I have to tell you, I just found out myself. I did not know about this till recently because I had a case in which this actually happened. And they're called Regulations and Directives Regarding the Registration of Marriage from 2013. And it's section 3317 in case you'd like to look it up. And so here, this is from the petition. This is from a protocol which I will read to you also at Grand Petition of the nursing mother who wants a marriage license. March 2013 court. Do you still live with your partner? Yes, we were waiting for a marriage permit. We have been living together for 4 months. I stopped breastfeeding 2 months ago. In other words, the court is asking her, are you, who are you sleeping with? And, are you still breastfeeding the child of your ex-husband? Do you have milk? This is from the protocol. I am not exaggerating. No, I do not. I stopped breastfeeding. And also, initially had problems with breastfeeding. I tried to use a breast pump, but was not successful. Court, did you take drugs to stop the milk? Petitioner, no. Are you going out with other men today? Petitioner, of course not. I love him. I do not want anything else but to be with him. In other words, they're trying to figure out who she's sleeping with, and it's this new guy that she's sleeping with who she wants to marry. Is she sleeping around? They're investigating who is this guy exactly. And in this case, they did something else happened with it, and here it is. Okay. Next. And if again, we're in privacy, right? This is all about the private bodies of women. How much more invasive of a woman's privacy can you get if you're dealing with her breasts and you're asking about her breasts and you're asking who she's sleeping with? And if the state, and now the ex-husband, fear that the nursing baby, and this is what happened in this case, is not the ex-husband's, they will demand that a sex trial be conducted to establish who exactly is the baby's father. Again, the state has passed regulations, procedural regulations regarding matters of legitimate genealogy from 2003 to allow for such trials of suspected children, right? The children who are suspected, they may not be really the children of who is allegedly the father. And here's a protocol. We're going to another protocol. From a hearing on that matter. The woman is trying to explain that the child was born here. I will read it to you because it's also pretty astounding. Court, were you together after the separation? The woman, we broke up in October 2010, and the child was born in November 2011. I've not found out the identity of the men who were with me at the club. Okay, there were a few. I know one was circumcised, and the other had a tattoo with a cross. They were Russians, but I had no information about them, and I cannot find them. Even if I see them, I would not recognize them. It was a one-time thing. Court, when were you with your husband for the last time? Woman, it's hard for me to say, maybe in June or July of 2010. Did you have sexual relations after your divorce? I did. I learned I was pregnant only after the divorce. After I found out I was pregnant, I was with someone. A week and a half after the get, I had sex with someone. Mr., the ex-husband, appeared because they brought the ex-husband in. They wanted to cross-examine the ex-husband. When did they have sex for the last time? Did they have sex together? Because they're trying to establish, is the ex-husband the father of this child or not? Both my mother and father are Jews. They're explaining that he's a Jew. And in October 2010, I severed all connection, and we did not have sexual relations even a few months beforehand. Now, what is happening here? Okay, what's his story about the cross? What's his story about the circumcision and the tattoo? Well, this is a whole lecture in and of itself, but what the woman was trying to establish, she had already said that the child was not her ex-husband's, which is the presumption that a child born after a get is the ex-husband's. That's the way the state of Israel tries to solve its problem of mamzer, okay? But this is not a solution, because a child wants to know who the father is, and the child, you know, and if the mother is in a relationship with another man who happens to be the father of the child, that person wants a relationship with the child and doesn't want to have to adopt who may have been his biological child, which is the solution. It's a whole complex arena with how they try and solve the mamzer problem. But in this case, what the woman was claiming was that she had had an orgy with non-Jews. Okay? And the way she knew that she was having an orgy with non-Jews was because the person that she had sex with, this is the trial that's going on, you have to understand, was not circumcised and he had a tattoo. Now, if she had had sex with a non-Jew and the child was the child of a non-Jew, then the child's not a mamzer. So that's what was happening in this trial, which is insane, right? Don't you think it's insane that in a democratic state, this is what's happening? Okay. So I just brought you this case because I found it very interesting that Barak was once asked if to decide a case in the Supreme Court whether he can introduce into evidence a photograph of his wife having sex with another man. And in this case, the state did not allow it. And I don't really understand how they reconcile this particular case with all these sex trials that are going on, but this is just something that I'm noting. Okay, so the rule of law, what is this? So we're talking about the human rights violations that are caused because we've adopted Din Torah law as the law of the land of Israel. We did privacy, we did liberty, we did privacy, and now we're going to talk about the rule of law. Jewish divorce rules and the Jewish state that incorporates, enforces, and imposes those rules also infringes on our right to a fair trial and the rule of law. This right, again, is enshrined in the Universal Declaration of Human Rights. Everyone is entitled to fair equality, to full equality, to a fair and public hearing by an independent and impartial tribunal. However, in Israeli rabbinic courts, there is no rule of law or fair trial when it comes to the demands of women who want to be released from marital captivity. For one thing, we women are not being judged by a court of our peers, since only men can act as justices on Israeli rabbinic courts. For another, Israeli rabbinic courts do not act under those circumstances for all intents and purposes as courts of law, as we actually already heard. They do not even act as arbitration panels. They don't act as arbitration panels. They do not adjudicate or arbitrate because there is no cause of action for divorce for women under Jewish law. They act as best as mediators who try to negotiate a divorce for us women. As Rachel explained to you, they cajole, they try and have women buy their freedom. They may cajole husbands. They may recommend divorce. At times, they may even penalize a recalcitrant husband. But in the end, they can do nothing without a husband's agreement. And at worst, as all of us who work in this field sadly know, sometimes the easiest way for an Israeli rabbinic court to negotiate a divorce is to convince a woman to give in to extortion, arguing that her liberty is worth whatever price is being asked. And because rabbinic courts act as mediators and not as adjudicators, women who open up files in these courts can find themselves enmeshed in negotiations for years on end, sometimes with no resolution at all. So, take as an example the case of our client whose husband was an admitted homosexual. Excerpts of her case are included in the source material. Okay. The client opened a file in the rabbinic court in 2002 asking for divorce. In 2006, the court ordered her husband to divorce her. But in 2008, the court repealed its 2006 order. Though the husband still had not delivered a bill of divorce to his wife, he was now willing to agree to terms that the court mediators thought were fair, as Batya explained also in a recent case that she has. So the court repealed its original order, making it clear that it had been a mere recommendation in the first instance. Furthermore, in full contempt of all the court's orders and recommendations, the husband did not release his wife from marital captivity until 2014, 12 full years after she first asked for divorce, 12 years. And the only reason he did so, why did he give a divorce after 12 years, right? When he was ignoring the rabbinic court orders and doing this, because he wanted to go abroad to marry his homosexual lover, okay? And the lover was not an Israeli citizen, and the state was threatening to deport him. So when he needed to, when he was willing to agree to give the get, that's when he gave the get. So I don't think I have to read you the material or the case, but it's very, it's interesting to see how the first thing the woman does is say, my husband's a homosexual. He really more or less doesn't deny it. There's proof of that. I think Batua was involved in the case too. And what happens is they order him to give a get, then they withdraw the order saying, we know we ordered it, but we're withdrawing it because now he has terms that we think are fair. Okay. Equality. Again, Jewish divorce rules and the Jewish state that incorporates, enforces, and imposes those rules also infringes on our rights to equal treatment by the state. The Universal Declaration of Human Rights has declared that all persons are equal before the law, and so does the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, to which Israel is a signatory. Article 16, okay, here's my Article 16. Sorry, I have to go back. Okay, Article 16 states that parties shall take all appropriate measures to eliminate discrimination against women in all matters relating to marriage and family relations, and in particular shall ensure on the basis of equality of men and women the same rights and responsibilities during marriage and its dissolution. That's, in other words, there's this international treaty which we've signed in which we say that women are to be treated equally also at the time of divorce. So that's, that's pretty good, right? But we signed on reservations, okay? However, Israel has specifically stated its reservation with regard to Article 16 insofar as the laws of personal status binding on the several religious communities in Israel do not conform with the provisions of this article. So long as there are religious communities that don't agree, then we don't have to treat women equally. Okay. Deferring to personal status laws of religious community, the state of Israel discriminates against women by applying different divorce rules to men and women. And so this is just one example of the different divorce rules. If a woman commits her adultery, right, her husband can be set free of their marriage. Here's where I differ with what Rachel was saying. Rachel was saying women and men have a cause of action for divorce. Women do not have a cause of action for divorce. Men, if they do come and say, my wife, and can prove that their wife committed adultery, the men can, what happens is, he's released of all obligations to his wife, and he can take another one if his wife refuses to accept her Jewish bill of divorce, which he has set aside, the bigamy rule, the exception to bigamy. If a man commits adultery, we already know that proof of this is not enough to release a woman. She, as we have already seen, cannot be released from marital captivity until her husband agrees to. So it doesn't matter if, in the case of the two cases of the husbands that are in jail or jumped out of the window, neither of those women, by the way, neither of those women's husbands had committed adultery. It was, I make a joke. One of my favorite jokes when I deal with this case is there's a concept in halacha ma'is alai. And I say, what does that mean? When ma'is al bet din, they will apply sanctions against the husband. When the bet din is fed up, okay, it's not when the woman is fed up with the husband that they will put the husband in jail, but when the bet din is fed up with dealing with the case, then they will do something and maybe put the husband in jail. So it wasn't that it was a case of adultery or anything like that, but it doesn't really matter because even had Shai Cohen committed adultery, and even if the other fellow who's sitting in jail for 15 years had committed adultery, that still doesn't help her because she's still going to be married until he agrees. Okay, and now recently, to underscore this inequality, the state has proposed unequal legislation to make it even easier for men to take a second wife. This was recently proposed in 2017, and I have a longer quote from here, but what they're trying to do is right now, if a man wants to take a second wife, if he sues for sanctions, he has to wait 3 years before he can ask for a second wife, and they don't think that's fair. He should be allowed right away to take a second wife, so they've proposed legislation which further underscores the inequality between men and women because, as you know, women have no recourse. They can't take a second husband. Security of persons. Universal Declaration of Human Rights. Everyone has the right to life, liberty, and the security of persons. Liberty and security of persons are very close, but the Istanbul Convention of 2011, the Council of the European Convention on Prevention and Combating Violence Against Women and Domestic Violence. Now, the Femmes for Freedom, you remember I spoke about Femmes for Freedom in the beginning. They're very connected to the Istanbul Conference, and let's look what happened in this Istanbul Conference, which was also the source of the conference that I went to in November, which was one of the highlights of the conference. Purpose of the convention. The purposes of the convention are to protect women against all forms of violence. I'll go back to my written thing. And finally, the Jewish divorce rules and the Jewish state that incorporates, enforces, and imposes those rules also infringes on the security of our persons. The Universal Declaration of Human Rights protects our security of our persons. In 2011, in a convention held in Istanbul, the European Union declared all forms of violence against women, emotional, economic, and sexual, are violation of human rights. Thus, I conclude this talk about marital captivity as a human rights violation to underscore that marital captivity is a form of violence. Marital captivity is bad for Jewish women. It causes us emotional stress, anguish, shame, and infringes on our dignity. It stigmatizes our children, and it estranges us from our communities. Ironically, as a result of a series of cases I brought for the Center for Women's Justice, the family courts of the State of Israel have recognized that these harms occur as a result of marital captivity. And then I ask you to read from the protocol of a decision made by Judge Menachem HaKohen in 2004, in which he awarded 425,000 new Israeli shekels to women whose husband had denied her request to be released from marital captivity. And the reason I chose this, the Center for Women's Justice, in my capacity both as the founder and founding director of Yad Lisha and the founding director and current director of the Center for Women's Justice, I filed many scores of these cases all over the country and set precedents all over the country with respect to marital captivity, which now I will call it marital captivity, as a form of emotional violence and reason to award damages for women. But in this particular case, Judge HaKohen does talk about the mental state of the woman. And in this particular case, actually what happened was the woman was dragged around for 10 years from rabbi to rabbi. And each time the husband said, if you go to Rabbi A, then I'll give you a get. She'd go to Rabbi A. That Rabbi A would promise. Rabbi A would tell the husband, you have to give your wife a get. And then he would say, no, if you go to Rabbi B, then I'll give you the get. And it happened like literally for 10 rabbis. So this is what Judge HaKohen says. The defendant placed the plaintiff in a difficult mental state of helplessness and absolute dependence on him with respect to the termination of their marital bonds. This helplessness, all of us actually are in that state, right? Because we're all dependent on the wills of our husband. And I have to apologize to my husband, who I love very much. I didn't mean to in any way say anything, but okay. Insinuate something, while entrapping her in a no-win situation. On the one hand, her agreement to apply over and over again to an arbitrator, to a mediator, or to some rabbi would prolong her suffering, distress, and aginut, and would not bring her relief. In other words, on one hand, he said, you have to go to another rabbi and another rabbi and another rabbi, and that wouldn't give her relief. But on the other hand, her refusal to do so was liable to cause the rabbinic court to designate her with the appellation of one who anchors herself, as the court, in fact, so ruled in its decisions. The defendant adds insult to injury, and side by side with his stubborn and continuous refusal to grant the woman a get, led her on, deceived her, and gave her a runaround. In other words, he's describing also the abuse of her dignity. It's not only that she's distressed by the fact that she can't get a get, but he just abused the get process to infringe on her. Can you imagine the frustration of going, I'm finished, of going to the bet-in? Sorry? Well, okay, so in summation, so there I am, I'm in summation. So this I'm taking from Femmes for Freedom again. Women who live in marital captivity are trapped for long periods of time, even decades, in a state of limbo and unable to rebuild their lives. This is discrimination and violation against women. States need to take all appropriate measures to also eliminate this discrimination against women. In summation, and most importantly, the state must end its involvement in this abusive divorce regime. The state must, as Femmes for Freedom notes, do everything to eliminate marital captivity. And certainly the state should not be intentionally and with malice aforethought putting all of us, you and me, into marital captivity in the first instance as the only state-sponsored marital regime. It cannot allow for the human rights infringements that ensue to our and our daughters and our granddaughters' liberty, privacy, right to fair trial, equality, and security of persons. Thank you.